Welcome to Week 8's recorded lecture, where we'll continue to cover the topic of hearsay. We will be covering pages 255 to 260, 271 to 279, 289 to 312, and 318 to 330 from your casebook. The first case that we cover is State v. Carlson. This is a Supreme Court of Oregon case from 1991. At trial, one of the issues was whether the defendant had drugs in his home. The plaintiff had offered testimony that when the police asked the defendant about tracks on his arm, the defendant said that the marks were injuries from working on his car. The defendant's wife then said that the defendant was lying and that the marks were from drugs. In response, the defendant hung his head and shook his head back and forth. The plaintiff then offered these statements from the wife as an adoptive admission at trial. The defendant claimed that he was shaking his head as a rejection of the statements, not an acceptance. The issue was whether the intent to adopt these statements was a question of fact or a question of conditional relevance. But instead, the court held that these statements were admissible for the truth of the matter asserted as hearsay because of an exception, and noted that the statements could be admitted as an excited utterance. We will then, in class, go over the two casebook hypos from page 259, so please be prepared to discuss as a class. The next case is United States v. Dewar. This is a United States Court of Appeals from the 7th Circuit from 1989. As background, the defendants in this case were operating nude dancing clubs and a massage parlor. They were charged with prostitution-related crimes that had allegedly occurred at these establishments. Two statements were admitted against the defendants as a conspirator exemption, which is, in this case, a conspirator told a third party that putting a red curtain on the patio was asking for problems with the police, and then a conspirator then teased his brother, saying, "I can't believe you don't know what's going on." The issue at trial was whether these statements qualified as the hearsay exception, and here the court said that no. The statements did not qualify, and therefore they were hearsay and inadmissible because they were not in furtherance of a conspiracy. And from your readings, you'll see that this was the hearsay exception under FRE 801 D2E, where a statement is not hearsay if it's offered against an opposing party and was made by the party's co-conspirator during and in furtherance of a conspiracy. So in this case, while they were offered against an opposing party and by a co-conspirator, the statements themselves were not in furtherance of a conspiracy and therefore not qualifying for this exception. The next case is Borgelli v. United States. This is a Supreme Court case from 1987. This case excerpt actually deals with the same FRE 801 D2E co-conspirator exception. In this case, an informant was working with the FBI to arrange the selling of some heroin to Leonardo. Leonardo agreed he would help find people to distribute the drugs, and then later said he had a friend who wanted to buy heroin. In a subsequent call, the informant spoke to the friend, the defendant in this case, about the quality and the price of the drugs. The informant and Leonardo then arranged the price and conditions of the sale, and then Leonardo would transfer the drugs from the informant's car to the defendant. The FBI then immediately arrested both Leonardo and the defendant, and at trial, statements by Leonardo were admitted as evidence against the defendant as admissions of co-conspirators. The issue in this case was whether those statements qualified as a hearsay exception, and the Supreme Court held that yes, they did. The statements were in furtherance of the conspiracy and made by the co-conspirator offered against an opposing party. The next case we covered is United States v. Boyce. This is a United States Court of Appeals from the 7th Circuit case from 2014. The excerpt from your casebook is a concurring opinion by Judge Posner. For background, this case involved statements made during a 911 call. Judge Posner's concurrence discussed the hearsay exceptions of present sense impression and excited utterances. For the present sense impression exception, the judge in this case notes that the immediateness of the statement has been stretched in cases to periods as long as 23 minutes. He felt that even immediate statements don't guarantee the truthfulness of the statement, and that a hearsay exception really violates common sense, because the thinking is if something is said as a present sense impression under that immediateness, that it must be truthful because the party did not have time to come up with a lie. However, the judge feels that this doesn't actually make a lot of sense. Similarly, with the excited utterance exception, the judge felt that this was even less justified. So he does acknowledge that the excitement of the statement might lessen the probability, again, of the declarant giving a self-interested statement, but notes that the stress of an excited situation or excitement can actually distort the declarant's observations and judgment, and so, again, does not guarantee truthfulness. The issue was whether the 911 statements were properly admitted at trial. The court held that yes, unanimously, they affirmed the conviction and said that the 911 statements were properly admitted. Judge Posner ultimately states in his concurrence that his wish is not to reduce the amount of hearsay that can be admissible, but to simplify the law. And so instead of having so many exceptions to hearsay, to change the rules around hearsay in general. We'll then again go through casebook hypos from page 291 and 292 in your casebook. Our next case is Davis v. Washington. This is a Supreme Court case from 2006. For background, this case involved complaints of alleging domestic violence. The complainant made a 911 call while the alleged assailant was still in the house. The holding in this case was that the court held that the first part of the call was not testimonial, even the part identifying the assailant, because it was made to resolve an ongoing emergency. And so the issue here was, again, that testimonial statement issue that we've talked about in prior weeks, which invokes the confrontation clause, meaning if a statement was testimonial, the defendant has a right to confront that witness at trial. So the question that we had here was, when did the 911 call stop being testimonial? And a reminder, these testimonial statements or evidence are statements made with some formality, statements where the declarant reasonably expects that these statements might be used at trial. In this case, the court gave 3 different answers to that question. The first was after the operator had enough information to address the emergency, or 2, when the assailant drove away from the premises, and 3, when the operator told the victim to be quiet and then asked her questions. So does the court's reasoning make sense? Was identifying the assailant necessary to resolve the emergency, or was that statement by the victim made in contemplation of a legal proceeding? By giving the assailant's identifying information, was the victim hoping that the police would find and prosecute him? Probably. The next case we covered was Michigan v. Bryant. This is another Supreme Court case from 2011. In this case, the police were responding to a 911 call and found Anthony Covington on the ground near a service station in Detroit, bleeding out from a gunshot wound. When each officer arrived, they asked Covington what had happened. Covington said that the defendant had shot him through a door at the defendant's home 6 blocks away and 25 minutes ago. Covington then drove himself to the spot the police found him and then died hours later, and the defendant was tried for murder. At the first trial, there was a hung jury, and then at the second trial, the defendant was convicted. The Michigan Supreme Court held that admission of Covington's statements violated the Confrontation Clause. So the issue here was, did the state court properly find that Covington's statements had violated the Confrontation Clause? The Supreme Court actually reversed this decision, finding that the deceased statements were not formal to the point of invoking the Confrontation Clause. Justice Scalia and Ginsburg both dissented. In Bryant, in this case, the Supreme Court gave a broad, general approach to determining what is a testimonial statement. It expanded the primary purpose language of the Davis case that we just discussed. So in the Davis case, the rule that you would use was, what was the primary purpose of that statement? If the primary purpose was testimonial, then the statement itself is testimonial. However, after this case in Bryant, the accused now has the burden of establishing that the primary purpose of the statement was to create an out-of-court substitute for trial testimony. So the court here created a reasonableness test, where the court should look to a combination of what the speaker intended and what the questioner intended, and then determine the purpose that reasonable participants would have had. So now there is a reasonableness test about whether or not a statement is testimonial. And so do you see any potential problems with this test? How do you determine what a reasonable person would be thinking in these scenarios that are so fact and case specific? In a dissent, Justice Scalia argues that the question should not be the declarant's primary purpose, but instead the declarant's expectation for how the statements will be used. Scalia argues that the declarant has to understand that these statements will be used against the accused in court for them to be testimonial. The next case is Mutual Life Insurance Company of New York v. Hillman. This is another Supreme Court case from 1892. For background, Mrs. Hillman brought an action against two insurance companies to recover for the alleged death of her husband. She claimed that a body found at Crooked Creek was her husband's, and the defendants, the insurance companies, contended that the body was someone else's. The defendants then needed to show that the person they believed was found dead had been in Crooked Creek at that time. They wanted to introduce letters from the alleged deceased showing he intended to go to Crooked Creek. The issue at trial was whether these letters from the alleged deceased were inadmissible hearsay. The Supreme Court held that the letters were admissible because of the hearsay exception of present state of mind. The letters were statements of an intent to do something in the future, though the Supreme Court held that this still falls within the exception. The next case is Shepard v. United States, another Supreme Court case from 1933. For background, Dr. Shepard was convicted of murdering his wife. As his wife was dying, she asked her nurse to bring a bottle of whiskey from her shelf and said this was the bottle of whiskey she had taken before collapsing, and that it smelled and tasted strange. The wife said that she wanted the liquor to be tested and said that Dr. Shepard has poisoned me. The issue was whether the wife's statements that Dr. Shepard poisoned her were inadmissible hearsay. The Supreme Court held that the admission of the wife's statements was an error. The statement was offered and received at trial as a dying declaration exception to hearsay. After trial and before the appeal, the prosecution realized there wasn't enough evidence to show that the wife knew she was dying, and so they argued instead that the statement was a state of mind exception to hearsay. The court held that if the statement was admitted as a state of mind exception, it could only be used to rebut the argument that Dr. Shepard that his wife had actually committed suicide. And since this was not actually what the prosecution intended to use it for, it was essentially saying that it could not be admitted for this purpose, for the state of mind exception. Also note that the wife's statements were likely testimonial. So as a question, why were the statements in Hillman admitted under the state of mind exception, but not in this case in Shepard? So the court sees a difference in the forward or future-looking statements in Hillman, in that case the declarant was going to do something, versus the statements of looking back in Shepard, in this case, to the past, the declarant saying that she was already poisoned. The next case is United States v. Feaster. This is United States Court of Appeals of the Ninth Circuit from 1976. The defendant, Angelo, was convicted of kidnapping Larry Adel. Adel's statements that he was going to meet Angelo was made immediately before his disappearance. This statement was then admitted against the defendant at trial. The issue is whether or not these statements fell under the state of mind exception. The court held that the statements were admissible and cited Hillman. Hearsay statements made by a declarant as to the future intent of a third party can't be used to show that person's probable conduct. So, for example, a victim's statement that X is going to kill me is inadmissible in a murder trial against X to show that he did kill the victim. However, in this case, the statement of going to meet Angelo expresses an intent of the declarant to meet the defendant, which is admissible under the reasoning of Hillman. It also incorporates a statement of what defendant is planning to do, which is inadmissible hearsay. So, what would be the argument for admitting this statement? The statement is clearly not testimonial, and if looking at just what the declarant is going to do, in this case, going to meet Angelo, it's that future intent that we saw admissible under Hillman, but potentially not admissible to show purely that Angelo, the defendant here, did kill the victim. We will then go over the casebook hypos 1 through 6 from pages 333 in your casebook, so please be prepared to discuss these as a class. And that's all the cases from this week. Next week will continue to cover the topic of hearsay.